Welcome to the Private Equity Exchange, the only summit bridging the gaps between limited partners, private equity funds, corporate executives, and entrepreneurs. With over 1,000 delegates, the Private Equity Exchange is the only venue where LPs, private equity firms, corporate executives, and entrepreneurs meet. Before the events, using our internet platform, schedule one-on-one meetings with delegates that matter most to you, and exchange far more than business cards at your deal meetings at the Private Equity Exchange. Gather great market insight with over 120 speakers and 6 tracks to choose from. The Private Equity Exchange, the largest private equity event in Europe for CEOs, funds, and LPs. You are looking at Restructuring and Turnaround, Turnaround and Law, Practice Evolution After Legal Revolution. Introducing
give you shortly the new legal and technical frame on the insolvency procedure, and then I guess we'll have more interesting experiences from my colleagues here. As someone says in a previous panel, this new law is really a new tool of restructuring, and I think it's a good thing for our, in France, our legal system. So since 1st of January this year, this new law took place, and there are some significant changes, and I will focus on those one quickly. There is the conciliation procedure and the mandat ad hoc procedure, which are amicable and prior to insolvency proceeding, are renovated. And the big new thing is this new safeguard procedure, which is open only to companies prior to insolvency. If they are into an insolvency state, they cannot ask for this new safeguard proceeding. Thank you. It has been said, and I think it's true, that this new law introduces a real change in our business culture, and it's a new cultural approach. The first big thing is the introduction of the creditors' committee, which was known in French law 30 or 40 years ago, but not in the previous law, the 1995 one. So these creditors' committee seek or are established to seek a consensual solution. It applies both in safeguard and in the turnaround procedure. I heard this morning Mr. Gunon talking to us, and I appreciated how important was the vote. We could all appreciate how important was the vote process, and the first success they got this week, I think, is a good step for Eurotunnel case, of course, but it's a good step ahead for this new law as well. The introduction of this new law has already seen a really great success in the pre-insolvency procedure, mandat ad hoc and conciliation. In the Paris area, the conciliation has been, the number of conciliation has been multiplied by 3, even more, even 4, which is huge. And the mandat ad hoc, I have been said by the Court of Commerce in Paris, that the number of mandat ad hoc proceedings have increased by 45 or 50%, which is really significant. There is, I think there is one reason to this success of the pre-insolvency procedure, is that the safeguard procedure has been very well marketed. There was a good communication on this new law all around France by all the actors, mainly the government, the Ministry of Justice, but everyone, the lawyers, the consultants, the administrateurs judiciaires, everyone. And we saw, and I guess the lawyers will confirm, that the directors of companies have heard about the new safeguards, and they come earlier to see their consultants and ask, if my company is in trouble, can I use this new law? And most of the time, they end into a mandat ad hoc or a conciliation procedure, which can be more efficient for them. So there is this great success, and it's a first lesson that we can make. The new safeguard procedure has a great success too. We must remind that it's totally new in the approach, and at this time I think there are about 300, maybe more, procedure in France open since the 1st of January, which is not a great number if you compare it to the 6,000 or 8,000 turnaround procedure each year, and if you compare it to the 30,000 liquidation procedure. But still, for a start, it's not so bad, and I will prefer to say it's a success. If we can move on. This law in his cultural change is more creditors friendly as it was before. I don't think Mr. Fargas mentioned that, or I didn't listen, that the US law is really creditors friendly, and the European and French law was known as a debtor friendly, which is still true. But this new law introduced another point of view for the creditors. First of all, this new law introduced great reductions in lenders or investors' liabilities. And this new article in the law is a general article. It applies in all situations, not only in a safeguard situation. So it has not been mentioned yet, but on the legal point of view, Mr. Fargas said that the banks were reluctant to be hands-on a restructuring process. But with this new article in the law, they should, I think they will take more risk, because they are less at risk on their responsibility. With the lender's responsibility, the director's liabilities has been reduced in the law. There is a new money privilege into the conciliation procedure, which is a great, it's a good thing to attract people. But we see in practice, in the cases that we have, that this new money privilege is not fully asked at the end of the process. When we are to sign a protocol, at the end, the new money privilege with an homologation from the court is not asked by the banks, not that much. And there is another great new novelty in the law, that is that the public creditor can grant debt waiver, but so far the décret d'application, the rules under the law has not been implemented yet, so we are still waiting for that. Okay, thank you. I made an overview, a small draft, just to mention that we have tools. That was, I said, at first, we have tools to help the restructuring process. In the blue, they are blue, yes. In the blue squares, you have judicial process, which means under the court, under strong court process, which is the safeguard procedure, in the case of Eurotunnel or Libération, and the known, because it's old enough now, the turnaround procedure. Both are judicial, and they both have an immediate consequence. It is that the debt is frozen. It frees the debt. On the orange or yellow, orange we said, circle, those are the pre-insolvency amicable process, mandat ad hoc, and conciliation. And in my green squares, which are still green, yes, those are the solution. Under the safeguard procedure, everybody seeks a safeguard plan. Under the amicable proceedings, mandat ad hoc, conciliation, it's a contractual agreement. And with one little exception, it stays confidential. And on the turnaround procedure, there are two solutions possible, either a reorganization plan, or, if not possible, a sale plan. I also put the liquidation process in the blue square because it is judicial, of course, and it can reach to a sale plan as well. We can move on. So I must accelerate, says my chief. So quickly, the mandat ad hoc procedure is the more simple procedure. It's an almost totally out-of-court procedure. I say almost because there is one court decision, which is the mandataire ad hoc appointment. It is totally confidential, which of course is a great tool into the negotiation. And when an agreement is reached, it remains confidential. If it doesn't work, no agreement, the procedure, the mandat ad hoc, just stops. Nothing special happens. No automatical safeguard or turnaround procedure. The conciliation procedure, it's also confidential, which is very important. It is also out of court only if there is no homologation requested by the debtor. On the opposite, when an homologation from the court is requested, there is an hearings and there is some publicity. This procedure, the conciliation, is open to a debtor, even if it has ceased its payment for less than 45 days. And it's a 4-month procedure, which I would say is not enough. And I hope that in the next future, this conciliation will be a bit longer. 4 months plus 4 months would be a good thing. I mentioned the new money in the conciliation procedure, and this is subject to homologation. I won't go further, just to mention that even if it's a real novelty, we don't see it happen very often into the conciliation that I say we, my colleagues, administrateurs judiciaires or conciliateurs, and I don't see so much new money privilege enforced. Then the safeguard procedure, there is one condition, very important, is that the company must not be into an insolvency state. It means it must not be into a cessation of payment state. If during the process, the safeguard procedure, the cessation of payment occurs, the court can swift the procedure into a turnaround procedure instead. Now, here is the big thing, our creditors committee. They are compulsory if the company employs at least 150 employees and gross sales are 20 million euros. And there are two committees, credit institutions and suppliers of goods and services. The suppliers representing more than 5% are compulsory into the committee. The other, less than 5%, can be invited by the administrator into the committee. We've heard that this morning there is a doctrinal debate so far on or whether or not the hedge funds or the buyers of the financial debts are members of the credit institution committee. From what I know, in the Eurotunnel case, there is yet one decision from the judge who confirmed that I think it's Octree Capital. He's member of the credit committee, credit financial committee, and now I think that will be into appeal, of course. So we are all very cautious about the next decision. A little focus on the vote rules into the creditors committee, which are very simple. Majority is 2/3 of the amounts and half the number of the members of the committee. The other one, like it was our use before under 1985 law, are consulted and they only give their opinion. It's not a vote. And then I will go fast enough, Mr. Chief, yes? And there the turnaround procedure, which is in insolvency procedure. I heard this morning that Mr. Thijs said that quoting Liberation, the safeguard is not insolvency, which is good for safeguard. I will insist on the fact that the turnaround procedure is a restructuring tool too, and not something that we should be afraid of. So it's open to a debtor who cannot pay his debts. It can reach to a reorganization plan, such as in the safeguard procedure. There are lots of similarities between the two. And the debt payments can last of a maximum of 10 years, which is not so bad, and with some exception, which will be with no interest rates. So sometimes it can be a very good tool to manage the financial difficulties. If the turnaround plan is impossible, then the administrator will seek for buyers of the company and will go into a sale plan. So that is my support to this panel, and that was the legal framework. Thank you.
I will avoid repeating what was just said before by Christophe, Thévenot, and I will try to revisit certain, I would say, key practical issues which a number of you, of course, should be well aware of when conducting a restructuring deal. Preliminary steps, I will not insist on that, but it's obvious that before taking a decision whether on the debtor side, whether on the investor side or the creditor side, you should first try to assess as much as possible where the debtor stays. First try to better understand the origin of the difficulties, also assess the cash needs for a time period which should be comprised between 3 to 6 months, so as to assess whether you would have sufficient time to implement the appropriate proceeding, whether an out-of-court or an in-court proceeding, because as you know, in any case, you would have to fund the business until you have the final solution in the complete form. approved by the courts and bound for everybody. And most of all, of course, you would need a realistic business plan which would allow everybody, creditors, investors, shareholders, the management, the employees, to understand what are the basic rationale for a pursuit of the activity, and just try to avoid entering into the wrong proceeding if you don't have any visibility as to the sustainability of the business, of course. So I will not insist on that, because these are not legal aspects of the restructuring, and I suspect that everybody is well aware of that kind of things. I would now revisit certain practical issues, which are very typical issues when dealing with restructuring in France or in other countries, of course. And I will, in each case, comment on the legal aspects of these practical issues. The first one is the funding of the business while building a solution. This is exactly what I said before. The main purpose is to avoid a disruption of the business, is to avoid insolvency to occur if there is any chance for the business to recover in another time framework than, of course, an insolvency proceeding. Of course, there are various means to avoid this kind of collapse. Obtain flexibility from suppliers as to the payment terms, obtain that shareholders would inject cash in the company, or have the lenders, banks, or investors bringing new money. This is obvious. Something which is not so easy to reach, and I would only comment on the legal aspect of these any new money injected in the company. As was just said before by Christophe Thévenot, there is a new lien under the Perben law, the new money lien. This is, as was explained, it aims as vesting any creditor which would inject fresh money in the company with the right to be repaid in priority to other creditors if there is any in-court proceeding opened afterwards against the company. But there are a number of conditions to be satisfied, of course, to benefit from such lien. The first one is, of course, to inject new money, but not equity, but loans, through a loan. And it should be new money in the sense that it should not be a consolidation of existing banking debts, of course. You should also have this new money injected in the framework of a conciliation proceeding, meaning that you should reach an agreement with all, stakeholders, creditors, shareholders, if possible, the company itself, represented by the management, to agree on a number of actions to be taken to remedy the situation and to preserve the sustainability of the business. This accord de conciliation is to be approved, homologué by the court, by the commercial court, of course. And if you have satisfied these three conditions, lenders having injected new money in the company could benefit from such lien. As was just said, it's not as often that we can see first new money injected in a company before any solution is found, of course, and it's not as often that we have seen how this lien could be enforced. But surely, in the next years, we should have a case law in this respect. The second practical issue which I would like to quickly present, is where do we stand with this issue relating to the liabilities of the lenders? As was said by Christophe Thévenot, the new law has limited the cases where creditors may incur liability in connection with any debts cash they provide or funds they provide to a debtor. The three cases where they could still be liable if at the end of the day the company collapses is if basically the cash was injected under a fraudulent scheme. Obviously this is something which is a repetition of existing rules under French law. They could also be held liable if they have been involved in the very management of the business. Again, this is something which is not new. And last, they may be liable if they have required disproportionate security interests, meaning that such security interest could be nullified by the courts, by definition, if the debtor or other creditors so requests. But as opposed, they would not be any longer liable based on the grounds which usually were applied before the new law, meaning that they had supported too long a company which had no perspective to recover. And this legal ground for a liability of the creditor does no longer exist under French law. Another practical issue, but I'm not sure that I will deal with it because it has already been presented by Christophe Thévenot, is how to deal with creditors. I would only insist on one aspect which maybe should be better understood by everybody. In the context of an out-of-court proceeding, whether a mandat ad hoc or a conciliation, it is obvious that you need a consent of each and any creditor which you want to have in the scheme. And it may lead to quite difficult discussions, and it may even lead to a collapse of your proposed restructuring plan. Now that you may, through a procedure de sauvegarde, submit your plan to a creditors committee which should approve the plan at a certain majority, this means that you can force creditors which are part of members of these committees to be bound by the terms of your restructuring plan, even though individually they would oppose the plan. If the majority consents to your proposed plan, it would also apply to these creditors. This is something which, in my view, would modify the leverage which a debtor has when discussing with the creditors in the frame of an out-of-court proceeding, because he could at any time choose to switch to procedure de sauvegarde, as was the case with Eurotunnel, and then have all creditors facing the situation and deciding on a majority vote. I would quickly jump into yes. Another practical issue, dealing with how to deal with shareholders. It may be funny to suggest that there is anything to discuss with shareholders, because in most of the cases, the shareholders are not willing to inject any new money and may be prepared to leave the company. But in fact, experience shows that in certain cases, shareholders are ready to dispose of their shares and to sell their shares to an investor, but they want first to have a price supplement in the event that the company recovers. And second, they want to avoid any liability with respect to their involvement in the running of the business or their participating to the recovery through an injection of cash, meaning that if there is after the plan is implemented, a collapse of the company, and that a court may try to see who could be liable for this collapse, the shareholders, at the time you are asking them to dispose of their shares and to leave the company, are asking for a protection, meaning that they want, in the share purchase agreement, an exclusion of any liability vis-à-vis the purchaser, at least. Legally, this could be achieved to the extent that no court has, at the time the settlement agreement is signed, take any decision as to the liabilities of the shareholder. So this is something which could be implemented within certain limits. Last but not least, how to deal with the management. You all know that there is a choice to be made there, keep it or remove it, of course, but I would like to insist on the legal aspects of the thing. In most of the case, you may discover at the last minute that there are golden parachutes, yes, applicable, meaning that the CEOs, the general manager may benefit from certain protections consisting in compensation they may be entitled to receive in case they are removed. So this is something which should be identified at an early stage of the process, just to avoid to be in a bad situation, having to discuss the implementation of these golden parachutes at a point where you did not expect to face such difficulties, of course. And you should also concentrate on the existence of an employment contract, which may be suspended during the time the CEO is vested with the powers to manage the company, but which would survive his removal, and then entail indemnities or compensations to be paid in case it is terminated. So I hope that this very brief presentation of certain practical key issues was helpful to you, and that's it.
So we prepared this presentation with Ivan Maltcheff, my colleague just in front of me, and he will answer to your question maybe after lunch. Our purpose is just to present quickly and briefly, because I think we will not have time, 3 case studies between France and Canada for this one, France and Eastern European country, and the third one between France and USA. Just to underline, if it's necessary, we are turnaround manager and we apply the law as a user, of course. First case. So the first case studies take place in Canada. So the context, a video game developer studio based in Montreal with 150 employees. This studio was a subsidiary of a distressed French company, and Zalis was called in at this crisis moment. The problem, at the beginning of 2005, the studio was short of cash, and we diagnosed that potential insolvency situation by the end of February, just 2 months to find a solution. So what could we do in such situation to avoid the bankruptcy? Thanks. So building a solution, thanks to the Canadian law, we organized the mise à pied temporaire, which is a temporary redundancy, which allows for temporary laying off of staff from a period of 1 day to 6 months. No notification necessary to the Canadian administration. Just it's better because the government could help you and send people to help you during the process. Therefore, this procedure is not made public, and the government pays up 70% of salaries during this period of time. The government may check later, maybe 6 months, maybe 2 years or 3 years after, that the company is compliant with the requirement of such procedure. So first, the government believe what you say. For a company which exceeds the 6 months period, then they have to plan the equivalent of a French social plan, a corporate restructuring plan of redundancies, or bankruptcy in the worst case. So during this period of time, so we lay off about 80% of the employee in this company. our team came up with a complete solid solution. In fact, after 2 months, the studio was sold to a major of this industry. And in conclusion, we compared with French practices, the action entails, in fact, the same cost of government with the social instruments. In comparison, if we try to compare, a French company has first to organize the redundancies, and such a situation can weaken the financial status of the company with a risk of bankruptcy, not sure, but in the worst case. So this procedure was not made, is not made public, and companies are not under a court decision, which is important. And good news, finally, the entire workforce was saved in this Canadian company. So let's move to the next case study. So the context was really different. A manufacturing company based in France in bankruptcy situation with thousands of employees, a subsidiary in Eastern European country, and this subsidiary was not in a bankruptcy procedure. But at the beginning of 2006, different reports established some financial issues inside the subsidiary. No real visibility on the situation and no real control of the subsidiary. So in the context of bankruptcy situation in France, how could we operate to get a better understanding? So the solution, the French court delivered an ordinance ruling for Zalis to undertake the operation. The subsidiary tried to block the procedure, but thanks to French and European procedures and negotiations also, it was overruled. And so we were able to conduct complete due diligence. We sent a complete multi-skilled team in this country. In conclusion, we discover, for us it was a surprise, that a legal decision taken in one European country was applicable in another European country. And fortunately, in that case, after discussion and negotiation, the due diligence was achieved properly and completely. So, I need to brief. Third case, the context, an international group based in the USA with tens of thousands of employees under Chapter 11, a subsidiary in France with hundreds of employees, and we were called at the beginning of 2005. The problem, previously at the beginning of 2004, this group had been slimmed down by laying off the employees in France. French lawyers helped the process to be carried out correctly. And unfortunately, in this crisis context, an internal procedural problem occurred during this formal process. And therefore, 1 year later, a French court took the decision to reinstate the employees in their job. So the US officers did not understand such a decision. And I remember an email coming from the CEO saying, CEO based in the United States, saying, stop paying them. So he didn't understand what took place in France, and in a conference call, he was really scared about this decision. So how to solve this complex situation between legal decisions, lawyers' procedures, and the lack of understanding of the US headquarters? So the solution, we convinced, in fact, all parties to enter into a one-to-one negotiation process. In fact, we signed a contract with each employee, and we drove the whole process till the end. In conclusion, understanding for us gaps and pitfalls between Anglo-Saxon and European laws, and priority should be given to negotiation over legal action, of course. So, if I try to conclude, all around the world for us, no good, no bad laws around insolvency and turnaround, just complexity, a context to play with, and of course, managerial aspect could help to play and get around the legal constraints.
I'm just trying to shortly illustrate a German possible solution to structuring and to better and closely monitor insolvency and restructuring proceedings. In Germany, we have, unlike many other jurisdictions, the option for debtor in possession proceedings in insolvency. The option was introduced to parallel the better-known solution in the US without major change in the insolvency law in 1999. The intention of the legislator was to give an incentive to companies to file earlier and also to have a cost effect, which is that the usual barriers and problems arising with the introduction of an insolvency practitioner could, to a large extent, be avoided by debtor in possession proceedings. What are the prerequisites? We do need the application of the debtor for debtor in possession proceedings, and it has to be brought forward and made clear to the court and to potential creditors that are also entering the scene that it has no negative implication on the proceedings as such. If you can demonstrate that and establish the trust of the court that that is the case, then debtor in possession proceedings can go ahead. It is a solution to overcome oh no, I'm sorry. Yep. What problems are we usually facing when we come and see cross-border insolvencies? We want to have a well-structured and coordinated process, which is vital. And we want to maintain as much as we can the advantages of an existing group structure, and we do not want to have and see individual or national egoisms play a major part. Now, on the other hand, from a national point of view, from a creditor's point of view, you may be concerned that you may run into strange alien insolvency proceedings under the EU directive. English proceedings are known. Yes, we've heard of them, but usually what the press reports on them is not that favorable that you really want to see that, and you have no proven experience with that. In addition, there are language barriers. I think we do see that day to day, or when we move around here, you may even get a better picture of that, and there are cultural barriers. So that may lead to a motivation in the national environment that you apply for secondary proceedings to be put in place so that you have something which you are more familiar with and that is not as strange to you. Now, if you have national proceedings, national secondary proceedings, you would be faced with a fully independent and fully in charge national administrator who would be very independent from the proceedings run elsewhere in Europe, and he would not have to follow any instructions or would have to align what he does with anyone else. There is the need for coordination. Obviously, the EU Insolvency Directive does not really very much to foster that. It just says that coordination should be there, but how that should be and the way that is meant is not further explained. Now, obviously, you would want in a group situation the sale of the business to the largest extent possible, and such a group sale would clearly be a problem if you have someone with very individual ideas and very individual powers run the business in Germany, and then it is very likely that such single sale or the inability to do a group sale will lead to a lower return and therefore would not be in the best interest of the creditors. Therefore, the idea of debtor in possession proceedings is a viable alternative. It will lead, or it does lead, as we have demonstrated in cases, to maintain the powers in one hand under the supervision of a local trustee appointed by the court. The administrators of the foreign proceedings or someone of their trust can be brought into the company as a director and then run the debtor in possession proceedings. This will ensure a higher efficiency while you're trading the business, because you will coordinate that and you will have the ability to fully coordinate that. And when you're selling off the business, again, you will have clear benefits from that. How do we get to that? When you apply, the local company or the administrators in the main proceedings can go about and apply for such debtor in possession proceedings. You should do that at a very early stage if you foresee that you want to do that or have to do that, because if other creditors have already entered the scene, you will have to have their consent for such debtor in possession proceedings, which obviously may cause additional discussions and some delays, as you may expect. What are the prerequisites? We do see that usually for debtor in possession proceedings, the courts as well as the creditors would find it unacceptable if it is run by the former management, as they would feel that it is inappropriate to have those run the business in the restructuring that have been unable to maintain the business in a proper position and are part of the problem, so they're not necessarily part of the solution. Also, the court wants the assurance that an insolvency process is properly managed, which is not surely guaranteed if you use the former management, and therefore it is of vital essence that you have someone in the driver's seat who brings about CRO expertise or administration insolvency expertise. Another slight problem may come about is we have preliminary insolvency proceedings in Germany, a process which, and that is a flaw in the law really, has not built in the debtor in possession process, so you have to overcome that. The solutions, I already indicated that you should have someone with the clear capabilities to present to the court and the creditors, and you will have to find a protocol solution for preliminary insolvency proceedings to get a smooth running of that. That was, in very brief, a bit of a flashlight on some German possibilities and German options in insolvency proceedings.
3 years ago saw the biggest single change we've probably seen in UK insolvency and reconstruction legislation for probably about 20 years with the implementation of the Enterprise Act. The introduction of this act was something that I refer to, and I think others refer to, as global cooling, a regime that's becoming more friendlier towards the debtor whilst cooling off towards the creditors. Why was the act introduced? Well, the existing regime we had in the UK, the receivership regime, was considered by many to be too blunt an instrument. It favoured one particular creditor, the secured creditor, and gave little regard to any other creditors. The existing administration process that we had was overly cumbersome. It required court applications, advocates, witness statements, and court hearings. The procedures just generally did not fit in with the spirit of reconstruction and business rescue. The new administration regime introduced by the Enterprise Act 3 years ago enables companies to be placed in administration quickly efficiently, and particularly at times of most need, i.e. when they're either going through reconstructing or threatened of insolvency. The new system is a collective procedure giving equal consideration to all classes of creditor. The model law, the UNCITRAL model law, was formally adopted in the UK in April of this year under the auspice of the EU regulations. And again, I don't intend to talk about the detailed implementation of this. I'm sure you're all fully familiar, and there's been more than enough seminars and papers written on it. However, what I do want to touch on is just a couple of examples where I believe bode well for the UK's approach to being flexible to cross-border insolvency. UK courts have traditionally been flexible and yet pragmatic in their approach and their attitude. And the following two examples that I just want to briefly run through, I believe, illustrate that quite well. Two European groups of companies, both involved in the automotive trade. I don't intend to go into the detail of the cases, particularly since in one of them, the administrator sitting in the audience and probably knows a damn sight more about it than I do. The first case I just want to touch on is MG Rover. In April 2005, administrators were appointed over the MG Rover Group, which was the manufacturing arm making MG Rover cars. Later in the same month, they were appointed over 8 of the national sales companies through which the cars were imported for distribution across Europe. The court was satisfied that the centre of main interest in this case for the sales organisation, was situated in England, and hence the applicable law to the administrations would be English law. A major concern to the administrator, however, was the possibility of secondary proceedings being opened in the other European jurisdictions. The issue being in principle that under local law, certain employees would fare much better than they would do if they were felt to be treated under English law. Hence there was strong pressure in these countries for secondary proceedings to be instituted. The administrators were concerned that to maintain some form of control and overall balance, maximise realisations and possibly employment, or if all else failed, to ultimately achieve an orderly wind down, then if the individual business was subject to secondary proceedings, this may not be the case. The administrators therefore sought, through the court, clarification that they could treat these creditors in accordance with the local law, which gives them far greater benefit, as I say, than their entitlements under English law. The court considered the administrators' powers to make these distributions under paragraphs 65 and 66 of Schedule B1, if you want to read it, of the Insolvency Act 1986. And without going into detail, in essence, this enabled the administrators to make certain types of payment to creditors and others for the overall benefit of the administration. In addition, they gave further regard to paragraph 13 of Schedule 1 of the same Act, which permitted administrators to make payments which would be for the overall benefit of administration, even though the persons receiving those payments would get more than under their strict entitlement under the UK law. Therefore, consequently, the court was prepared to confirm that the administrators had the powers to enable them to make the payments to the employees in accordance with the local law, as if secondary proceedings had taken place. Interestingly, however, the court went on to stress that the final decision to make these payments rested with the administrator and not the court, as it should be made on purely economic and commercial grounds. The other case that I'll briefly touch on, which I think also illustrates a similar sort of flexibility and pragmatic approach of the English court, is the Collins and Aikman case. Again, a significant organisation, a leading supplier of automotive components to all of the world's largest vehicle manufacturers. There were 24 companies in Europe spread over 10 countries. The administrators recognised that for the most beneficial outcome would only be achieved if they were able to adopt a coordinated approach to the administrations. Again, it was vital to them to avoid secondary proceedings being opened, since it was likely to hinder both the continuance of the business and the ultimate coordinated sale. The administrators consequently reached an agreement with the creditors across Europe that in consideration for not commencing secondary proceedings, then assurances would be given that as far as possible, the administrators would deal with the claims in accordance with the local law in each of the respective countries. The administrators were of the view that giving the assurance was critical to the successful outcome of their strategy. Ultimately, the administrators ended up with in excess of 120 million for $120 million for distribution across the European creditors. Considering themselves bound by their assurances, they applied to court to directions to make for directions to make distributions and to apply the rules relevant to each of the individual countries. Again, the court considered the relevance of the same paragraphs as they had previously, 65 and 66 of the Insolvency Act, and they found that jurisdiction did flow, but in addition it went on to say that administrators are expected to behave honourably. The administration regime is hugely dependent upon a degree of confidence existing between the administrator and the creditors. The fact that at the time the assurances were given, it was thought likely that they would assist in the achievement of the administration should then suffice to enable the administrators to propose, under paragraph 66, that payment should be made. Interestingly, the court went on to look at an old case, Ex parte James, when it said, which further gave support to the fact that the officer of the court, the administrator, should behave honourably. The high ethical standard expected rule and required of an officer of the court can thus outweigh even the prospect of a better realisation, and can do so even where there is no contractual obligation on the officer to ignore that prospect. Hence, whilst there appeared to be sufficient statutory provisions to enable the payments to be made, this rule in this case gave a strong contribution to the relevance of the directions given. I think both these cases, very quickly cantered through, illustrate the flexibility given by the English courts and the English law, and in particular, the English courts, and the willingness to assist in allowing the coordinated restructuring of groups across Europe while still protecting the interests of local creditors. I think it shows that the court is prepared to exercise jurisdiction flexibly and to be sympathetic towards insolvency regimes applicable in other countries. In conclusion, the changes in UK legislation 3 years ago have certainly streamlined, pity it couldn't be spelt right on the slide, but streamlined the procedure of administration, making it much more efficient and much more available to the aid and rescue of viable companies. The shift towards global cooling, as I call it, has removed some of the aroma that attached to insolvency, and as we now look to follow perhaps more of a US approach, hopefully enabling businesses to be saved rather than destroyed. This legislation is still in its early days, and only time will tell whether the Enterprise Act, the EU regulations, will actually truly come to the aid of cross-border insolvency and reconstruction and provide benefit to all. Ladies and gentlemen, very briefly, I thank you for your time.
I understand that every country has to deal with local, may I say, traditional proceedings evolving from time to time to adjust, but that turnaround practitioners have more and more to deal with conflict of laws, and which means needs of coordination between practitioners. I also understand that the ancestral model law that you have adopted in the UK could be a solution throughout Europe, but is today very much competed by some other countries like Germany. I don't know if you have any questions on the various topics that have been discussed today or on these very legal topics. Now it's your turn if you have any questions.
In both cases, gentlemen, you mentioned that there was a real need to avoid secondary proceeding in the countries across Europe. On what basis was this need so strong? Because we can imagine that to have secondary proceeding being coordinated between the administrator as far as the global interest of the company is the same, of course.
Well, I think maybe I'll give a brief answer on that one. I think, yes, you could have that and you can imagine to have that. But if you look at the case that has been talked about quite a bit this morning, which is the Collins and Aikman case with 24 operations in 10 jurisdictions, if you would assume you would have just 10 different administrators, and you do have a fully integrated group of companies that has very close links on the manufacturing side, to keep that process smoothly going with 10 personalities from across Europe with their own language, with their own ideas, and with their own concepts, I think that is something that is more than just a challenge. It is possibly impossible. And therefore, I think it is in the best interest of the company, of the employees, and the creditors to have a coordinated process which is run out of one hand. And I think we've seen that in that case. There was one country where secondary proceedings were put in place, and despite of the EU regulation calling for close coordination and cooperation, that was not the experience in the circumstances. I think we have
There is a question there.
If I can, I just wanted to just add a comment to that. I was in fact the administrator of one of the administrators of Collins and Aikman, and I think it's fair to say that the general rule was exactly that it didn't. It wasn't going to be helpful to have secondary proceedings because it was going to be difficult to coordinate it. But that wasn't the case in all cases, and the procedure that Michael described about the debtor in possession procedure that happened in Germany, we did put in place. So we actually took the steps to actually have secondary proceedings in Germany. Michael was involved. And that way it was entirely coordinated. The creditors' committees were the same, and it worked extremely well. In the other country that Michael mentioned, which was in fact Austria, where there was a hostile appointment, if you like, it broke down completely. So I think it's horses for courses. If it can work, it can be very powerful, but at the moment the laws are just not coordinated enough to allow it to be the case in all countries.
You were talking
Yes.
about the mandate out of court in your presentation, which seemed to be a very fast and effective way of doing business. And I didn't quite understand, when could companies apply this?
When they think they will face difficulties, it's a very open proceeding. Until the law that took place in the 1st of January, there was only one mention into the commercial law, saying that a mandat ad hoc exists. That was all. No article, no rules. Today, there is 1 or 2 articles saying that there is a mandat ad hoc and that it is confidential. And that's all. So the main interest is for the company is to show to the creditors that the company is under the eye of the commercial courts. And the second interest is to put into the negotiation a third part, the conciliateur, the mandataire ad hoc, the person who will conduct the negotiation, but not being involved into one of the party. He's not a lawyer. He doesn't fight against someone else. He helps the process. And the mandat ad hoc has seen a great success into its practice, and the efficiency, as well as the conciliation, is about 70% or 67, 2/3% of success. There is an agreement at the end. I hope I answered to your question.
And linked to this question, Christophe, I also have a question. How you have said that the new money possibilities that has been introduced by the new law is not very much used. From your experience, what are the main obstacles you may have experienced for the partner of the company to put new money?
To put new money or to ask for the privilege?
Both.
Well,
and mainly the second one.
To put new money into restructuring or restructured company is a question of economics mainly. That was a question of responsibility before the new law, because today, with the general article which I mentioned and that Christophe mentioned as well, the risk for the banks or the lenders has been minimized. The main reason why I feel that the banks, when they put some new money in, doesn't ask for the privilege is that they can get the privilege with a publicity. And because to get the privilege, the agreement must be homologated, if that is English, by the court. Okay, it must be enforced by the court. And this is a public stage. This stage can become public because you go at the court and there is an hearing. So from what I've seen so far, the banks themselves, even if during the preparation of the law, the banks asked for this privilege, now into the agreement that we can see, they do not ask for the privilege because of the negative effect of the publicity for themselves, because they don't want to that it is on the public stage that everyone knows they had put some money in or abandon, comment on dit abandon en anglais? Write-off, or made some write-off, of course.
Thank you very much.